with children. Please, can I see a round of applause, our virtual claps, our appreciation for this
Thank you.
outstanding profile and standing speaker. So much award, so much impact, so much lives that he has taught, he has trained, and we are so privileged to have him with us for this few minutes or an hour that we have with him. We are super certain that we are going to learn a lot. Some of us, this may be the word we need. If you remember when Madam Deborah spoke to us, said that just one word can keep set the fire in you running. Okay, so please get your pen and paper, and as we have Mr. Bolaji today. Thank you so much, sir. Over to you, sir. Thank you.
Thank you so much for having me. And all those things are just Sakamanje, so to say. Actually, before I accepted this invitation to speak, I baffled with two things. And the first was that I don't know if I have the muscle to engage the learned colleague students in this heinous task. And the second is that I don't know if if I'm going to convince you during this presentation, due to the fact that you are well learned and well, you are still learning. But be as it may, please, I only want you to just erase everything you know about forensics, so that you may be able to get something meaningful out of this. So we are talking about leveraging digital forensic for effective dispute resolution in the modern technological landscape. And starting with introduction, I don't know if you can see my screen.
Yes, sir, we can.
Okay. Okay. Starting with introduction. The emergence of information technologies has ushered humanity into an era of high technological communication and digital platforms. It has therefore revolutionizing the transfer of information, transaction, and of course, automations. This technological advancement has significantly transformed human activities and consequently reshaped the landscape of legal proceedings in courts worldwide. To keep up with these modern developments, it is crucial for the law to adapt accordingly to these changes. In our courts today, the judge ultimately determines which fact establish specific consequences. Consequently, forensic evidence can only be viewed as opinion evidence, though it may be referred to as such in a condescending manner. Opinion evidence involves drawing conclusions and inference from observable and communicable data or facts. It can be presented through oral testimony or in written reports. However, the evidential value of oral testimony can be affected by various considerations, just as submitting a written report with proper context, which eventually may carry little weight. Digital investigator can reconstruct data from operating system of different computers, mobile devices, and cloud servers. A methodical incident response process help law enforcement officers and even the first responders to ensure evidence integrity and dependability of digital device, digital media gathering, investigation, analysis, and of course, reporting. Preserving digital evidence in the right way is key to forensic investigative credibility. Digital forensic is not limited to law enforcement. For instance, commercial and criminal investigation need digital forensics. Private business use cyber forensics for audits, compliance, and investigation, which is eventually crucial in a data-driven business world. Digital forensic can also be improved by competent computer forensic analysts. This type of person can speed up data recovery through organized analysis and encryption examination. Digital forensic examination have a variety of applications. The most common is to support or refuse a hypothesis before criminal or civil court. Criminal cases involve alleged breaking of law that are defined by legislation and enforced by the police, and prosecuted by the states, such as murder, theft, and assault against the person. In civil cases, on the other hand, it deals with protecting the rights and properties of individuals that is associated with family disputes, but may also be concerned with contractual disputes between commercial entities where a form of digital forensic referred to as e-discovery. Digital forensic is the act of recovering and analyzing the content found in digital or on digital devices such as desktop, notebook, netbook, tablets, smartphones, etc. It was little known a few years ago. It will interesting to note that the United States of America, who happened to be the lead in the digital forensic investigation, established their first computer forensic laboratory in the year 2020. However, with the growing incidence of cybercrime and the increased adoption of digital devices, this branch of forensic has gained significant importance in the recent past, thereby augmenting what was conventionally limited to the recovery and analysis of biological and chemical evidence during criminal investigations. We have been talking about forensic science. We talk about the digital forensics. There can never be digital forensic without forensic science. So what is forensic science, and how, what is the relationship or nexus between forensic science and digital forensics? Forensic science is the applications of scientific techniques to legal matters, or you can refer forensic science as the intersection between science and law. When you apply forensic science to law, you are referring that law as scientific law, which is used to describe what has happened. And in this case, the scientific theory explains why or how those things happen. We have various branches of forensic science, and we have about 68 of them, but we are going to be mentioning just very few. When you hear something, the word forensics without the science also means forensic science. So if you want to write forensic, you must write forensic science. If you are writing forensics, you don't need to include science. So the S at the end of forensics is means science or interpreter to science. So under forensics, we have the crime scene investigation, which is called the CSI. Most of us may be used to the television series movie CSI on our digital televisions. And the other one is laboratory examination results and, of course, reports. The CSI are field agents, while the laboratory examination results and reports are laboratory agents. These two people are expected to know how to present their expert opinion in court. So we understand that the proceedings begins at the crime scene. Other branches of forensic science include question document analysis, server forensics, fingerprint forensics, forensic tool marks, which can also be regarded to as forensic ballistics, forensic toxicology, forensic serology, forensic chemistry, forensic anthropology, forensic audio, video, and image analysis, forensic anthropology, forensic psychology, and what have you. This brings us to the type of digital forensics. I once heard about the branches of forensics. Let's return back to our subject for today, which is digital forensics. We have various fields. Digital forensics is a generic name that have some types of digital forensics under them. So when you hear something about media forensics, we deal with retrieving data from storage media you are also referring to digital forensics. When you hear something about network forensic, which analyze the network activities of events or directly the origin of a security artifact, you are also referring to digital forensics. Wireless forensics, which gather and analyze the data from wireless and network traffics. Database forensics, which analyze and investigate databases and metadata. Software forensics, this investigate crime committed with the use of software. Email forensics. Email forensics deals with recovering or investigation that have to do with the use of email that is being used to commit a crime. I don't know. Some people will tell me that they are being sexually abused, and we don't know how to gather information, even as law enforcement officers. How is that possible? What happens to the question of how, where, when? And we may eventually get to know how to ask all these questions after this presentation. Memory forensics, evidence recovered from the random access memory of a system. And of course, the one in your phone now, mobile phone forensics. Mobile phone forensics, that's the use of the investigation conducted when a mobile phone is used to commit a crime. Digital evidence. Digital evidence or electronic evidence is any probative information stored or transmitted in a digital form that the party to a court case may use at trial. Before accepting digital evidence as a court or in a court, it is good for us to determine if the evidence is relevant with the case, if the evidence is authentic, because an hearsay or whether a copy of acceptable or original is required. For a digital forensic examiners, they don't work directly on the evidence recovered from the crime scene, because we have digital autopsy. Digital autopsy is a replication of a digital evidence from the crime scene that is being used for analysis for presentation in court. The only reason why you don't work on that is because there may be a need to call on others, expert opinion to come and analyze that. If you have tampered with the real evidence, be rest assured you are in for it. I know some of us who do watch football. That means you are a gunner. Some of the popular electronic devices which are potential digital evidence are hard disk drive, compact disc, DVD media, backup tapes, USB drive, biometric scanner, digital camera, smartphone, smart cards, etc. The digital evidence are used to establish a credible link between the attacker, victims, and the crime scene. Some of the information stored in the victim's system can be a potential digital evidence. Some of them are IP address, system logins, remote logins, detail, browsing history, log files, emails, images, etc. Are you aware that even as a legal officer, you can actually know where an image was taken by yourself, not going through any forensic experts? Digital forensic encompasses various techniques used to collect, preserve, and analyze electronics data. It is essential for uncovering evidence in legal dispute, ensuring that the information is reliable and admissible in court. Locate principle of exchange. This is a guiding principle for all forensic professionals all forensic, digital forensic examiners, and everyone practicing forensic field. So according to Edmund Locard, Principles of Exchange, he stated, and I quote, "Every contact leaves a trace." Dr. Edmund Locard was a student of biometrics at Bertillon in France. He got educated in medicine and law. First, he was the first to suggest 12 matching points as a positive fingerprint identification. Edmund Locard exists between the year 1877 to 1966, and he was considered the father of criminalistics. Criminalistics is another word for crime scene investigator. He built the first world forensic laboratory in France in 1910. Phases of digital forensics. Phases of digital forensics. Sorry. The phases of digital forensics were cut across the first phase to 9th phase. I'll be looking at all of them one after the other. The first response. The first response, you can also refer this phase as the first responders phase. Sorry. This can be referred to as first responders phase. And when you talk about first responders, you cannot think anything less than the first person that arrived a crime scene. It may be a police officer, it may be in a case of disaster management, it may be NEMA, National Emergency Management Agency, and maybe Boy Scouts, it may be Red Cross. These are first responders. So the first response, that is the first phase in digital forensics. Search and seizure phase. To find evidence and data, the team examine the crime's device. When you get to this phase, after the first responders get to the crime scene or to the scene of crime, it should be important for that first responder to look for evidence that may be relevant to the case at hand, and that is search and seizure. When you search and seize, you have to label those evidence, then before you move to the third phase, which is evidence collection. So as a professional, you use the device that have been found and seized to gather data. At this stage, because we are talking about digital forensics, you must understand that you don't just pick a mobile phone. You pick a mobile phone and just put it in an envelope as a forensic examiner. That is a no-no, and that is a foul. So if you are a counsel to your clients, and a digital forensic examiner said he collected a phone and dropped it in an envelope or a paper bag or any other evidence bag apart from Faraday bag, then that means that person has failed the evidence integrity. And the fourth one is secure the evidence. Security of the evidence is paramount. So evidence is maintained in a secure location by investigators. You know, the culprit at large may also be somewhere very close to you, having proximity to you, and be looking at you to see how they are going to get the evidence you have gathered from that crime scene. So evidence security is quite important. Data acquisition. You have to retrieve the alleged digital assets through process known as data acquisition. You must acquire data in this phase of your digital forensic examination. Data analysis. You have to examine and identify, classifying, separating, and of course, modeling the data you have already acquired. And the seventh is evidence assessment. Investigator evaluate the ESI in relation to the security incident after identifying it as evidence. If you identify something as evidence, you have to understand that everybody in the courtroom, because your evidence is going to still end up at the courtroom, and everybody in the courtroom don't understand your jargons, like gas chromatography, mass spectrophotometer. They don't understand that. Please, what does it mean? What does it mean? You have to assess all this evidence and ensure that you use non-ambiguous or non-cryptic words. 8, documentation and reporting. A feasible data record must be created. Must create a data record that that is needed during your defense in court. At this stage, you are going to. That is why you see so many bigwigs in the legal profession organize a mock trial before attending to court cases, and this has helped them a lot. And the last one is expert witness testimony. According to the section 68 of Evidence Act, let me quote what it was. I don't want to quote it wrongly. Yes, opinion of expert witness when applicable. And I'm right, section 68 of Evidence Act. So you must understand that you are serving as expert witness in court, and you are to just submit your reports and understand that it's only the judge that have the say. Either is going to be your evidence, the evidence you presented is going to be admitted as exhibit or not. Rules of digital evidence. I call it the golden rules in digital forensics or in forensic science. So we have the relevance, we have the authenticity, and the integrity. The relevancy, the evidence have to be relevant to the case at hand. Sometimes when you get to the crime scene, you realize that you are dealing with breaking an entry, then you now see a pants that is stained with blood. That means there has been maybe a form of rape or so. We are not dealing with rape. We are dealing with armed robbery. That was the reason why you are called for to that place. So by the time you bring in non-relevant things when you are presenting your digital evidence in court, then it's a no-no, and that evidence may not be admissible. The authenticity. The evidence presented must be authentic, and it must meet the standard at which it is presented to achieve. Then integrity. Chain of custody in this process must be adhered to. Chain of custody is a chronological movement of evidence from one person to another before you get to court, and we must understand this. And if chain of custody is not observed, then we are not there yet. Characteristics of digital evidence. We have the admissibility, reliability, completeness, convincing to judges, and of course, authentication. Starting with admissibility, it must be in conformity with common law and legislative rule. There must be a relationship between the evidence and the facts being proved. Digital evidence is often ruled inadmissible by courts because it was obtained without authorization. In most jurisdictions, a warrant is required to seize and investigate digital devices. Some of you, if not all, and I've been saying, this police, they just seize, they just collect your phone, they start searching the phone. Do they have such right? They don't have such right. I know my right. Yes, we understand, but in so many cases, they may not. If anybody, if an armed robber came to rob a place, and the mob arrested him and police get to that place, you think the police should not collect the phone? That means the law has to be reviewed. In a digital investigation, this can present problems where, for example, evidence of other crimes are identified while investigating another, just like the case I mentioned earlier. The evidence must be from undisputed origin. Undisputed origin. You cannot be dealing with armed robbery case. Then you said you have water inside inside uh, a cup. How do we know that the water was inside the cup in the first place? That water can be gotten from anywhere. So please, it has to be reliable and completeness. The evidence should prove the culprit's action and help to reach a conclusion. As a digital forensic examiner, you are uh, you are uh, um, you are giving a legal support to the court through the scientific means to gather evidence. And this, you must understand, it may either exonerate the innocents and convict the criminals. Meanwhile, if your evidence is going to convict the innocent, then your evidence is not complete enough, it's not reliable, and it should not be admitted. You have to be convincing to judge. The evidence must be convincing and understandable by the judge. And this I've explained earlier. You are just like every other person in court. You are not. You are to just give your opinion and not to tell the judge. For example, if a counsel, you as a counsel, you ask a forensic examiner, Mr. Bolaji, yes, I've gone through your reports. It's a fantastic work, and I really love this. In fact, we only need to have 4 people like you in Nigeria, and our criminal judiciary system is set, and we are going to enter a new dawn. But Mr. Bolaji, are you saying the evidence you collected at that crime scene belonged to Mr. Hay? Then the digital forensic examiner said, yes, it belongs to Mr. A. He has failed because it is only the judge that can determine that. As a digital forensic examiner, you cannot say that. You cannot decide that because you are to remain unbiased and remain neutral at all times. Authentication. The evidence must be real and related to the incident. The investigator must be able to prove to the authenticity of the digital evidence by explaining the reliability of the digital equipment. If the digital equipment, according to that section 84, it was reviewed this year, and if the digital equipment is up to date, if the programs used inside the digital equipment is genuine, if it's not pirated. If it's pirated and your counsel have access to that information, even if it's a paper document that was presented to court, like a report, and the dates of that computer you used to print that or to process the documents is not correct, then it does not meet the requirements from that section 84. Digital forensics in dispute resolution. Digital forensic is a critical tool in dispute resolution because it can help uncover evidence that is legally admissible and can change the outcome of a case. It can be used to recover deleted data. Let me tell us a story. But before then, digital forensic can help recover deleted files, trace unauthorized access, and identify data exfiltration. In 2016, I witnessed a case at Abuja High Court. It was a case of federal government of Nigeria versus a serving senator. I'm not going to mention his name. The serving senator was alleged to be involved in terrorism financing, and before his his phone was an abandoned seizure. When they went to arrest him, he abandoned his phone, and they got some facts from the phone. Meanwhile, because our police were not properly trained, they just got those facts and they were taking pictures with another phone. This was what we get, and that was what they were able to present in court, and of course with the phone. And the phone was accepted as an exhibit in court, but the court decided to now invite an expert opinion to recover, because by the time you get to court, the chain of custody process has been broken, so the phone has been formatted, has been wiped out. So we got to the courts with Celebrite device, and Celebrite device is a tool used to recover, to provide digital forensic solutions, and we're able to recover those files, and they were so glaring. Funny enough, we still lost that case. Why? We lost the case because we did not mention that we are going to use any other flash drive to copy the recovered data from that Celebrite device before we present it as exhibits. And because we did not mention that, we were taken to be the one to the integrity of the evidence we are going to provide as exhibit to court is not is faulty, so it's not going to be admitted. So because of that, we lost that. And we understand that even if it's adjourned and we have to present that thing again, we may not even see anything again. So that is one of the legal technicality that you must understand. Create a timeline. So digital forensic can be used to create a timeline. A man and a woman has been communicating for a very long time. Then the woman told you that he has never seen him before. They've not chatted. They've not had any conversation before. When you have access to their digital devices, we have to up our game as legal officers. Prove or disprove claim. Digital forensic can provide evidence to prove or disprove claim in litigation and, of course, dispute resolution. Digital forensic can also be used to ensure data integrity. It can help to ensure data integrity in corporate and, of course, in a legal context. And in a civil cases, digital forensic can be critical in civil cases such as fraud, embezzlement, defamation, and blackmail or extortion. Insolvency matter. Digital forensic can help uncover fraudulent transaction, hidden assets, and other financial irregularity. It can also be used in workplace investigation to investigate employee misconduct, data leakage, and of course, corporate espionage. Digital forensic investigator or examiners are trained to extract, review, and document digital evidence in a way that is legally permissible and admissible. They often work with in collaboration with legal counsel, just like you. Let me say this. If you are working in a chamber and you have a digital forensic related case, please, it is important that you consider inviting a digital forensic examiner to come and give support. And you may not, but because we don't want to pay professionals for their knowledge, we just believe we can do everything. And in so many cases, you will lose that case. Even when you have a very strong point to win, that is no longer permissible by you youngsters. Digital forensic as an evidence-based case. The aim of digital forensic is not just to find a culprit or repair any damage. An investigation has to provide answers to questions and demonstrate why those answers are credible. The question goes along the lines of who, what, why, when, where, and how. A case file may be required for numbers of reasons. One, to provide a basis for interaction with legal advisors and law enforcement. to support a report to a regulatory body, to support an insurance claim, to justify disciplinary action, to provide feedback on how such an incident can be avoided in future, to provide a record in case of a similar event in future, and of course, to provide further evidence if required in future. For example, if no action is deemed necessary at this point, but further developments occur. Challenges in digital forensics. Challenges in digital forensics has been grouped into three. I'm going to mention the three: the people, the process, and technology. The people that are supposed to present digital evidence or to process digital evidence collected from the various crime scene all over the country are not skilled to process that. Okay, let me tell us a case. During my internship at Banti in Lagos, we asked to, okay, I was deployed at the homicide department at Banti, and there was a case of six members of the family found dead out of 8 members of family. And getting to the crime scene with Lagos ADN and for Forensic Center, Dr. Richard Somiari, and of course with some police officers. On getting to the crime scene, the police want to take over the case. Meanwhile, the people that worked with us, some of them have no skill to process such crime scene. Getting to that place, the police officers saw a paracetamol at the dining table and a dispenser water. He took the paracetamol and dispenser water and took it, telling me that he was feeling headache. I shouted at him, and he nearly resorted to fist combat because I would not even allow that to happen in my. You don't even know what killed these people. We are still investigating. In fact, we have not even. We are still doing walkthrough of the crime scene, and we are already taking. What if is the same paracetamol that killed? That's what non-acquisition of required skills can do to people. When you don't have the skill, the required skill to do something, please don't dive into it. Don't dive into it. There must be an awareness for you to understand what you need to understand, and the organizational silos must be filled. If you are going to work with an organization. Processes. The life cycle and maintenance culture, especially in this part of the world, is lacking in exactitude, and we must ensure that the maintenance culture and, of course, our life cycle of the life cycle of equipment is extended by our maintenance culture. And service disruption has been a challenge also. Sometimes ago, I don't know if I'm the only person. I'm using an MTN line, and there was a time that we were told that the underground optic fiber cable under the sea was disrupted, was caught by a whale or a fish. I don't know whether it's kote or panla that caught the cable. And funny enough, we were disrupted. Our network were disrupted for some days, 2 or 3 days thereabout. That is service disruption. Is a challenge in digital forensics, and it affects so many businesses. I believe we are going to see to that in technology, in the advent of several modern technology, innovative ideas and stuff, artificial intelligence. There has been so many system design, network design, and innovations, and this has formed a huge challenge to us. If you don't understand how something works, and there is no way you can make good use of that. When you don't understand how WhatsApp works, just give your phone. somebody very close to you, maybe your siblings at home that is still very young, has been hearing about WhatsApp, it has not used it before, just give him your phone. He won't be able to use it. Just start asking you question. And if you not ask you question, he will know. Digital forensics process. Digital forensic process are divided into five stages, and it starts with identification and end with the presentations in court. In identification, you have to collect the right evidence. It's not all evidence that is relevant to the case that you call to investigate. It's not all evidence. So you must understand that it's not all evidence that are right evidence. And number two is preservation of those evidence. You have to maintain the integrity of those evidence. We have to ensure that the security of those evidences are paramount to you. Analysis, you have to determine the result accuracy. After the laboratory or even inside the laboratory, you have to ensure that you take out your time to analyze well. Documentation, document findings to use in court. In this stage, that's where you have to set up a mock trial. And setting up a mock trial, if you call somebody like me, the kind of question I will ask you, even as a legal officer, you won't believe I've not even gone to the four walls of law school before, because it is just important that a forensic professionals understand Evidence Act. This Evidence Act is like the Bible for all forensic professionals. So this is their Bible. So if you know it as a legal officer, then you have a better chance to prove or disprove any evidence they bring. And of course, the fifth one, presentation. You have to summarize and present your findings through a report writing in court. And don't forget that you are going to serve counsel the copy of this report, and you have to serve them minimum of 24 hours before the commencement of the proceedings. And if you are doing this, you should know that they will have also gone to analyze your report. I'm ready for you to ask questions. Techniques used in digital forensics. There are several techniques used in digital forensics. We will be mentioning just a few of them. We have reverse steganography. Cyber criminals use steganography to hide data inside digital files, message, or data stream. I mean, send a picture to you. What you have seen is picture, but I'm telling you, I've already sent a virus to your system. And in fact, everything in your homes that is digital will catch that virus, because it's going to replicate itself. So reverse steganography involves analyzing the data hashing found in a specific file. When inspected in a digital file or image, hidden information may not look suspicious. However, hidden information does not change the underlying as or strings of data representing the image. And the second one is stochastic forensics. Stochastic forensics help analyze and reconstruct digital activity that does not generate digital artifacts. So stochastic forensic help investigate data breaches resulting from insider threats, which may not leave behind digital artifacts. Cross-drive analysis. Cross-drive analysis, also known as anomaly detection, help find similarity to provide context for the investigation. It typically involves correlating and cross-referencing information across multiple computers drive to find, analyze, and preserve any information relevant to the investigation. Any information that is not relevant to investigation, cross-drive analysis is going to sieve them out. Live analysis and, of course, deleted file recovery. I gave a deleted file recovery example with my experience in 2016. Tools used in digital forensics. There are several tools used in digital forensics, and these include oxygen forensics, Paraben, NCASE, open test, Wiresharks, autopsy, volatility, Nmap, Cinnamon, Next Editor, Sift, Celebrites, and so on and so on. We have so many of them. I've mentioned Celebrite when I was talking to you about how Celebrite tool was used to recover the deleted information from that mobile device. Legal framework for digital evidence. It is elementary law that facts are established in court by credible evidence. Facts must be proved unless they are admitted, presumed, or judicially noticed. The fact could be established through oral testimony, documents, and real evidence, that is, physical evidence. In the evolving landscape of Nigerian law, the admissibility of digital evidence has emerged as a critical issue, profoundly impacting legal proceedings across the country. This presentation delves into the nuance of digital forensic, digital evidence, its admissibility in Nigerian courts, challenges faced, and the evolving legal framework governing its acceptance. The admissibility of digital evidence in Nigerian court is governed by various laws and rules, primarily the Evidence Act 2011. And of course, Section 84 of the Act specifically addresses the admissibility of electronic evidence. It states that electronic records are admissible if they are produced in accordance with the provision of the Act relating to the admissibility of computer-generated evidence. However, despite the clarity provided by the Evidence Act, challenges persist in practice. Issues such as authentication, integrity, and of course, the chain of custody of digital evidence often arise, thereby requiring careful consideration by legal professionals and judges. Significance of the chain of custody. Chain of custody is a record of paper trail that shows how real and digital evidence was found, held, moved, analyzed, and thrown away. Keeping a straight chain of custody, make sure that the evidence that is used in court is the same evidence that was gathered during the investigation. You don't just say because you pick warm water from the crime scene and the water fell off from you, then you are now going to present another water because all water na water. It's a lie. All water no be water. It is important for proving the evidence reliability and legality, which help protect against claims of tampering or wrongdoing. By carefully writing down every steps of the progress, from gathering the evidence to presenting it in court, forensic expert protects its purity and make sure it can stand up to legal review. Admissibility condition of digital evidence. For an evidence to be admissible in Nigerian courts, digital evidence must meet certain conditions, including the document must be produced by a computer during a period in which it was regularly used to store or process information. If the computer you use to process an information you want to present to court is not in regular use, then if the other counsel is aware that that thing is not in regular use, you may present that before the judge, and your evidence may not be admitted. The computer was operating properly and receiving relevant information during that period. It must be operating regularly, and they must have been using it and giving informations and receiving output in that regard. If multiple computers were involved in storing or processing information during that period, they are considered as one computer. If you are presenting an evidence and that evidence is gotten from, like, let's say 15 computers, those 15 computers are regarded as one. Digital device tool, as we mentioned earlier, or application use were not pirated. Even to your Microsoft Office. If your Microsoft Office is telling you Windows not genuine, please go to your setting and update. and the other counsel have access to that information. 0 to you are a gunner. Guidelines for presenting evidence in legal proceedings. You have to adhere to legal standards. There are legal standards that make sure that all the proofs you gather follow the laws and rules that apply to digital forensics. You have to maintain a clear chain of custody. I've told you earlier, where you have to write the names of all the people who touch the proof, when they touch it, and what happened. To stop charges of tampering or pollution, there must be a clear chain of custody. Use understandable language. You don't use cryptic words. I've said it earlier. You have to prepare to defend your findings. Experts should be ready to defend their result and explain how they came to them when they are questioned by other experts. Visual aids. You can use pictures like chart graphs, sketches, and of course, timeline to help show that you found complex information easier. Future of digital forensics. The future of digital forensics is promising with advancements in artificial intelligence and machine learning, enhancing analysis capabilities. As technology evolves, so the tools and methods used for effective dispute resolution. Legal officers must lead to meet this advancement by equipping themselves with required skills through training, seminars, conference, and workshop, just the one we are doing now. In conclusion, the admissibility of digital evidence in court presents a pivotal junction where traditional legal principles intersect with technological advancement. As the use of digital evidence continues to proliferate, stakeholder must navigate this complexity. You must also understand that this complexity is a challenge for you, and you must equip yourself to mitigate those challenges. This presentation has explored the intricacies of digital evidence admissibility, providing insight into its legal framework, challenges, and processes, techniques, among others. As technology continues to advance, we must, as a matter of urgency, as upcoming legal officers, acquire skills to accommodate the complexity of digital evidence and ensure its effective use in our litigation process. Recommendations. It is recommended that early integrations of young lawyers like you is important. You have to integrate yourself, align yourself to the digital world so that you'll be able to meet up with the future digital challenges. You have to consult experts. You must not be like the rest that think they know everything. Even if your colleague who happens to be a lawyer, you understand this person is a digital, is tech savvy than you. Please, you have to consult that person and ensure you get necessary advice. Preservation of evidence. When a digital forensic examiner present his report to you, you must ensure to ask how those evidence have been preserved. And if they have not been preserved very well, please, you now understand that you must ensure his preservation before you go and mess up yourself in court. The chain of custody process, as we said, it's you have to write down the names of the movement of people from point A to point B that have touched the evidence. You have to utilize forensic tool. We talk about several forensic tools: the paraben, the Celebrite, the Oxygen, the HENMAP, the Cain and Abel, and the stuff. You have to ensure that the data analysis is performed by you separately, even from digital forensic examiner, so that you'll be able to know if there's any gap before the presentation in court. Training and awareness, just the way we are doing now. I want to commend the organizers for this privilege for giving to these youngsters. This is indeed a right peg in the right hole. Collaboration with the forensic team. So many law chambers are now collaborating with forensic team. Around early this year, a chamber got my article online, and they decided to contact me on the question document case. It was a forged will. It was a suspected forged will, and after looking at the will, actually, it was actually obvious. It was obvious when something has been typed since 1984, and you are seeing it now. You should know that in 1984, you only have you can only type that with typewriter, and if it is with computer, then it's not going to meet the regular format method. Like the format, that's the numbers, the font size, the font type, and stuff. So you must collaborate with forensic. Must collaborate with forensic team. They eventually won that case, and I smiled to bank also. There must be mediation and settlements. Digital forensic over the time has presented itself as a to provide a resolution, to mediate and settlement out of court, because it will be obvious. This thing is actually the digital footprints left by me. It cannot be. So if I find your picture online, you cannot tell me you are not the one that dropped that picture there, or you cannot even tell me that it's not your picture. But if you tell me it's not your picture, then maybe we have to use another tool to know where that picture was taken, and if it was taken where you actually took the picture, then you should know that's going to be a fallout for you. And with this, I just want to say thank you for giving me time to have this presentation with you. So I believe we'll be having an interactive session. These are references for further reading. Thank you.
All right, thank you very much, sir. Thank you very much. We are grateful. I learned a lot, and I'm sure each and every one of us that listened attentively learned so much. This is a completely new aspect of law and evidence that we are all learning today. I don't know about all of us, but I am learning today, and I have received insight into this, and I'm very grateful. Thank you very much, sir. Thank you very much. The class was very good. It was beautiful. Thank you, sir.
Thank you.
Okay. If everybody, all of us here, if you have learned a lot, also please react. If you are ready to, interact with our speaker for today, yes. If you have questions, you have to wait a little bit. So we are going to first of all confirm if we actually listened and if we learned today. So I want to ask a few questions, very few questions, maybe 1, 2, 3, 4, 5 questions though. Then I'll give you all opportunities to ask our speaker questions. I don't have a lot of questions because this is new. Digital forensics. Forensics is also mostly here in movies though, but ladies and gentlemen, sorry, ladies and gentlemen, it is coming to us, to our doorstep, into the palm of our hands today for the first time. I'm sure it's for the first time for many of us. So let's go straight into the questions. If you are ready, please react. Yes, react, because okay, so let's quickly go through the rules of the question. So if you know it, raise your hand. I might speak randomly, or I might pick the first person that I see. If you know the answer, please do not say it in the income messages. Let me pick you so that you'll be able to, I'll be able to give as many people as possible opportunities to answer. All right, please do not type the answers in the income messages. This is very much against the rules. All right, so my first question is, can somebody give us about 3 characteristics of digital evidence? Three characteristics of digital evidence. All right, Abasiama Lawrence.
Hello, good afternoon.
Hi, good afternoon.
Okay, I actually raised my hand to ask a question, but I'll go ahead and answer this.
Okay,
So,
okay, that's it.
the characteristics include admissibility, reliability, and completeness.
All right, thank you very much. That is correct, yes. So I'm going to, list out a few more so that we all learn, in case for those that maybe came late or do not remember. So characteristics I have here is convincing, it must be convincing to the judges, it must be authentic, it must be reliable, the digital equipment must be reliable, the measures taken to ensure the accuracy must also be entered. The method of storing the data, yes, must also be entered, and the reliability of the computer programs used to process data. Yes, many of these methods and some of these methods can also be found in the Evidence Act, which was reviewed, yes, this year, yes. So to include digital evidence. All right, let's look at another question. All right, thank you, Abasiama. You are very correct. Please put down your hand. When it's time to ask questions, ask your questions, I will definitely give you the chance because me to have my own questions, Sha. All right. So Mr. Bolaji gave us some challenges that we have in digital forensics. Can somebody give us about 3 challenges we have in digital forensics? All right. Daniela Damabide or Damabide. I'm sorry if I'm pronouncing your name wrongly. I'm very sorry.
No problem, no problem. Damabide. I hope you are hearing me, please.
Yes, yes.
Okay. Some of the challenges include people, experts' testimony, privacy concerns, and technology.
All right, thank you very much. Somebody else can also come up and give us another 3. Yes. Are we active here? If you're active, please give me a reaction. I don't think we're active here. Can you hear me?
Yes.
Okay,
Yes,
please,
we can hear you.
okay. Someone else will come up and give us another 3. Yes, please. Another 3 challenges in digital forensics, because they are a lot. Okay, it seems we are not asking for this question. All right, let me throw in a very a question that maybe he did not touch here. Okay, concerning these challenges in digital forensics, can somebody like pick one of these challenges and profile a solution to this challenge? Everybody can hear me, right?
Yes, I can hear you.
Okay,
Yes, we
okay,
can.
Oma Ikor.
Hello, everyone. Good afternoon.
Just pick one challenge and profile a very good solution that is practicable. It's practical. Sorry.
Okay. Hello, everyone. Good
All right.
afternoon. Can you hear me?
Yes.
Yes.
Okay. If I remember vividly what he said, he mentioned about 3 core challenges. He talked about the people, the process, and the technology. So I'll focus on the people because he gave an example of when he went for a crime when he went to a crime scene with some police officers, and then one police officer wanted to like take a paracetamol that was on the table and some water there.
I
That
said it
shows
took.
that most of the
He did
times,
not want to take. He took.
okay, he took. Oh, Now that
Okay.
shows that he does not have the requisite skills like to work in that particular environment. And I think this is a problem that most police officers face. And I believe one of the ways that we can provide a solution to this problem is by ensuring, or not necessarily us ensuring, but the police itself ensures that it trains its officers in this light. Because most of the times when things like this happen, the people tend to take actions to the police. So if the police themselves are not well skilled, then it can lead to loss of evidence that can be very important in discovering whether or not this person is the person that did this, or this person is the person that did not do this. So I believe like
Thank you very much.
maybe 6 months training, trying to fix it in, and trying to like get experts to teach these people how to like manage such circumstances and situations when it comes to criminal cases. Thank you.
Okay,
All
let
right, thank
me
you very
let
much.
me add to that. Let me add to that.
Yes, ma'am. Thank you, sir.
Okay, as legal officers, you must also understand that you hold us a sense of duty to know what digital forensic and its presentations in courts entails. And until you know all these things, you may not be able to challenge anyone when presenting wrongly in court. So if you understand this, you'll be able to challenge. And by the time they see that you are challenging, even when they don't want to learn before, they want to learn now, because they don't want to come to court and mess up. Thank you.
All right. Thank you very much. Thank you everyone that answered. Thank you, sir, for the additional information. So if you have your questions, wait, everyone put their hand down because we are also limited for time. If you have your questions, I'm gonna do fast. Sorry. I want to pick the first 3 people to raise up their hand. I did not say go now. Omar, please. Omar, please. Okay, the first 3 people to raise up their hand are going to get their questions answered. Then the rest, we put it in the in-call messages. So in case he sees one that is interested in answering, he might answer it. But he might not answer all your questions, and we are also limited for time. So the first 3 people to answer, to raise up their hands. Go. All right. So we have Omar Iko, Abasiama Lawrence, and Akindeju Kofo-Worola. All right, thank you very much. So let's start with Omar. Omar, please ask your question.
Okay, I have a question. You mentioned that, I think, something relating to privacy. When he said, he gave this example of going to, let's say, a crime scene where armed robbery had just happened, and then somebody says, you don't have a right to collect my phone, and he says that it's part of evidence or something. So I just want to ask, does it matter how evidence is gotten for this digital forensics? Does it matter that a private person can say, no, I don't want you to have, would I say, access to this, my property, let's say my phone or any personal property as it stands? Like, is it possible for the court to say, no, we're not going to admit this evidence because you did not get it properly, or you breached the law when you're trying to get this or this? Thank you.
Okay, can I go ahead to give answer to that?
Yes.
Okay. If I may get your question, you're asking if it matters, a private person's consent matters in releasing his or her devices for investigation, if I may get it right.
Yes. Yes.
Okay. Now, you must understand that even in a crime world, you have degrees of crime that you can commit, that options of fine and a community service may not be there. So if such crime is committed, let's say a murder, something like an homicide crime has been committed by somebody, and the person is still claiming fundamental human rights. As at that time, you can't claim fundamental human rights. When they take you to police station, you can start thinking of fundamental human rights. But as at that time where the crime was committed, they can collect your phone, they can collect anything from you. And by the time you get to, that's the reason why they will ask you not to say anything until maybe you get a counselor that is going to talk on your behalf, or that is going to guide you on how to talk or what to say. So it is important you understand that, yes, you have fundamental human right to release any information at your disposal willingly, but not when you go and kill somebody, then you are now claiming that you have fundamental human rights. They will call your bluff that fundamental human right should go to hell first. We are going to arrest you, and we are going to collect this device from you. And that time you may not be able to. But apart from a serious crime, please, you have your fundamental human right to say, I cannot release my device for you because it is my personal property. Thank you. Is that okay?
All right. Thank you very much, sir. Thank you, Omar, for asking your question. Yes, thank you very much, sir. Okay, so Abasiama Lawrence, please ask your question.
Good afternoon, sir.
Good
Thank you
afternoon.
so much for this session. I've really learned a lot and it has really sparked my interest. So I have a couple of questions, but I'll try to be as quick as possible. The first question is relating to the framework basically for fingerprint evidence. So as the story you mentioned, I know that from reading and all that, that in more developed countries, in a crime scene, when the investigators go in, they always go in with gloves, and before they even take anything, they've worn gloves so as not to tamper with the evidence. But in situations in countries like Nigeria, where that's not very crime investigators don't really pay attention to that. Can a lawyer use that as a basis to dismiss the credibility of evidence in court? And how sophisticated is fingerprint technology in Nigeria, using that in court? And then my second question is the possibility of a lawyer also doubling as a forensics expert or an investigator. Thank you, sir.
Please come again with your second question.
Okay, my second question is about the possibility of a lawyer also doubling as a forensic expert. The two career paths, how possible that is.
Okay. Okay, thank you so much for that, those wonderful questions. Okay, the first one, I'll respond to the first one. Framework for fingerprint evidence, how sophisticated it is, and how relevant it is in our courtrooms, and of course among the experts today. Yes, forensic is very new, but be as it may, I've been a forensic scientist for past 8 years in Nigeria, and I was trained by a university in Nigeria. So it means those people that train me already have required knowledge to be able to train me before I was trained. So it means we've been having some form of forensic specialist in Nigeria for quite some time, more than a decade. And to answer this fingerprint evidence framework question, I will ask a question, but I will answer that question myself. Do you think we have fingerprint database in Nigeria? The answer is yes. Okay. Why do I answer yes? Because some of you may be like, why is he telling us what we know doesn't exist? You don't know it, but if I tell you now, maybe you may begin to understand the angle I'm bringing my ears from. Have you registered for NIN? If you have registered for National Identification Number, then the government have your fingerprints because you register with your biometric detail. Do we have anyone in this lecture today that did not have a bank account? Please, if you know you don't have a bank account, just tell me I. So nobody. So when you are ready, when they are creating the account for you, do you do any biometrics? Yes. So central bank have your biometrics detail. Some of you have, not everybody have a permanent voters card. And what have you have done so many things. So we have for a fingerprint database but we don't have centralized fingerprints database. What is missing is to make these things centralized and to ensure that a proper policy or law is established so that as the giver to someone in the hospital, that fingerprint is going to be taken, and because it's a unique identity. No two persons in the world have the same fingerprints, not even identical twins. So it's so how sophisticated the fingerprint is, highly sophisticated because you are unique to your own fingerprint and it can be traced only to you. People don't go to crime scene with gloves, with a coverall and stuff. Yes, maybe before. Now, things have changed, or things is changing. Let me say, things is changing. I think we are about, let me say, we have about 45% there, and we are doing what we think we can do to encourage others that there is need for them to protect themselves, to protect the integrity of or to sustain the integrity of the evidence they are trying to get from that crime scene. So possibility of a lawyer doubling as a forensic expert, yes, it's even make it better. It makes it better. You are going to see, you ask questions as if you are specialty in both, and this is what we actually need. I believe this should be part of what this training is meant to achieve. And I would not be surprised if some of you really want to go into forensics after your first degree program. After you have already been called to bar, you just want to go into forensics. You will know more. You will know more. I learned about 18 fields of forensics, so it's going to be somewhat difficult for anyone to come and tell me what is not in forensics. So I know if I don't use my glove and I collect an evidence in a crime scene, I cannot present it because there must have been cross-contamination from me to that evidence. And if I'm presenting it in court, it must have been written that during the time of recovering this evidence, I was not with personal protective equipment. Thereby, there is a cross-contamination of this evidence through me. So if I state that in my report, then that means the integrity of that evidence can still be sustained because they can actually rule that cross-contamination out. That's going to be determined by a judge anyway. I hope I've been able to answer your questions.
Yes, sir. Thank you very much.
Yeah.
All right, thank you very much, sir. Thank you very much, everybody. Please, due to time constraints, we can't take any more questions. I'm sorry, Kofo. I'm very sorry for that. Miss Sarah,
They
please, do
can
you have
send,
anything to add?
yes, yes. They can send their question to the group, okay? You can send the questions to the group, and then from there we'll know how to take care of it. Sir, just as a follow-up to your response that a lawyer can also double as a digital forensics investigator. Now I'm looking at the modalities in executing that, because as a lawyer in the process of carrying out cross examination, and then one of the duties of a forensic investigator is that you must remain unbiased.
Yes.
You cannot say you are the one with the weapon, you know. So, but you must be able to give evidences to prove. Um, so what I'm trying to ask now, sir, is how do you wouldn't it be a clash of personalities, a clash of um ethics, where you are as an investigator, you are remaining unbiased. As a lawyer, how do you marry that? Or is it that in a particular case, because from looking at rules and all, in a particular case, I'm finding it hard to understand how a lawyer can double as an investigator and also double as the lawyer handling or defending a defendant in a criminal case. So I'm looking at how will such a modality work, because there are several codes, ethics, rules when it as that affect each of these two personalities. So would that be possible
Okay.
in the same case?
Okay. Thank you for that question. Yes. Before you dive into that, you have to ask a question. What did you want to achieve? What you want to achieve is that you want to know about this other aspect of forensics, because you want to provide legal support, complete legal support to your clients. The only reason why I said you should consult digital forensic professionals during mock trial is for them to be able to guide you. Okay, this thing may not be admissible in court. This evidence cannot stand the test of time. There is a break in the chain of custody on this evidence. And if you understand this, you don't need to consult anybody. You may not need to present yourself to court as a forensic expert, but you have to use forensic terminologies. So even the judge that is presiding over that case will understand that no, this lawyer is different, is unique. If you know what people you are supposed to consult know, and you also know what they don't know, then you are ahead of them. So by the time they are telling you what they are not supposed to tell you, you can call them, no, this one is not supposed to be. You said this is a datum point, and you said vantage point and datum point are the same. How? What I understand about datum point is this. By the time you mention that to a forensic scientist, the forensic scientist understand that you know, and he will not want to mess up himself. So he will clearly answer that case. So it is there won't be a clash, because you are not going to present yourself to court as a forensic expert. You only want to know because it's really going to help your clients. It's really going to help you and help your career also. Thank you.
Amazing, amazing. Thank you so much, sir. That was beautifully answered. Thank you so much for such an insightful session. We learned a lot. I want to see our claps. I want to see our emojis. I want to see our appreciations. It was fantastic. It was amazing. Thank you so much, sir. Truly, truly, it was a fantastic session. Thank you to our moderator for for moderating beautifully. Right now, we would love to call on our pioneer in the person of Madam Deborah to give a closing remark as we gradually come to an end. Thank you so much. The emojis, even on our group platform, the feedback is amazing. We still have questions, but we'll communicate with our pioneer to see how we can send those questions to you so that you can help us with answers. I believe that some persons have gotten direction today and they will definitely make very good use of the knowledge that they have. Thank you so much, sir. Madam Deborah, I don't know if you're on this call before we for the closing remarks. Madam Deborah. Okay, okay, all right. So I just got a feedback from her right now. She's currently indisposed to attend to us, but nevertheless, sir, I don't know if you can permit us to take the questions we have, or if you are already out of time. I don't
Please,
know, sir.
you can go ahead.
Okay, okay. Thank you so much, sir. This question is from the group. It says, how can tampered evidence be restored to its original form, especially under time constraints in digital forensic investigation?
Hmm.
I don't know if I should read it again or if that's clear,
No,
sir.
I've seen that.
Okay, thank
If
you, sir.
if an evidence has been tampered with, it is no longer an evidence. Now, if an evidence has been tampered with, there is contamination and cross-contamination. When there are thin line between these two words, contamination and cross-contamination. Contamination involves the third party. Cross-contamination involves you as an expert. During the process of analyzing notes, recovering that evidence, you miss it and you contaminated contaminate the evidence. That is cross-contamination. And that is cross-contamination. And contamination is a third party, maybe because the first responders did not get there on time. You now have some goats moving close to that place. They even know, in the case of accident, maybe some people already got there trying to help the victims and stuff. That is contamination. They already contaminated that scene. So cross-contamination, you get there, you are trying to help, that is cross-contamination. And in this process, during the presentations of your reports in court, you must be able to understand that to sustain the integrity of either of your evidence through the contamination or cross-contamination, it must be stated, because you are not a robot, because you are not immune from making mistakes. So you must, if you make that mistakes, it must be stated. And if it's stated in your reports, then the lawyer can, the judges can now look at it. Okay, the cross-contamination will not be avoided because of this, because of this. Okay, so I'm going to admit this evidence. And if it's not going to be admitted, they are going to tell you the reason why it will not be admitted. So for further evidence gathering, you now understand what's the effort you are going to put in place. So I don't know if I'm able to answer that.
Amazing, amazing. That was fantastic. Thank you so much, sir. Thank you so much, sir. There's one more question, or I think she is having a network issue, and I know that she will give me sleep. Akindeju, please, you can ask your question. Akindeju. Go forward. Please ask your question, or you type it if you can't speak because of the network. You can type
All
it.
right, yes. I'm so sorry. Yes, my mic was still muted. I thought I'd unmute it. All right. Thank you
Okay, we
very
can
much,
hear.
sir, for that insightful section. I learned a whole lot. Okay, let me dive into it. Okay, so I wanted to ask that what are the ethical concerns in handling sensitive data during digital forensic, like during digital forensic investigation for dispute resolution? Okay, we know that individuals have right to privacy whereby they can only release necessary information and ensure that it's kept confidential. So, in that light, what are the ethical concerns in handling this sensitive data during digital forensic investigation for dispute resolution? That's the first question. Then the second question is, how can digital forensic be applied to resolve intellectual property disputes or cases of cyber theft? So those are my two questions, sir. Sir, please, sir, did you hear me?
Yes,
Right.
I'm just trying to write them down. So your first question is the ethical concern as regards the presentation of digital evidence, right?
Yes, sir.
And your second question is how can the digital forensic be used to resolve intellectual property or disputes?
Yes, or cyber crime, yes, or cyber theft, sir.
Okay, or cyber theft. Okay. When you talk about data privacy, everyone understand data privacy, or most people understand data privacy. And that's the reason why social media has made it more revealing to know your rights, that you have rights to protect your mobile device. And your mobile device is your personal properties. And with this, it must also be noted that the data privacy is your concern and is what you hold in high esteem. If it's what you hold in high esteem, then you must understand what it takes. It is not in all cases that data privacy can be proven, or can be sustained, or can be claimed. I mentioned earlier that in a case of armed robbery, okay, somebody raped a lady and it was caught in the act. Then you are telling me about the, data privacy. Yeah, to hell with data privacy. I'm going to call your bluff and I will collect that device first. Okay, what is the reason why mobile device or digital evidence is to be put in a Faraday bag? Faraday bag is a silent bag that protects the device inside it from external waves or external networks. So if my phone is dropped inside a Faraday bag, you cannot call, you cannot make call to this phone and it goes. You cannot do remote wiping. That means you cannot erase the phone remotely. And you are not supposed to off this phone before seizing it. You are not supposed to off it after seizing it. So, but because it's inside Faraday bag, it has protected any external network from getting inside that device. So because of that, it cannot the battery will not drain fast, and it is just expedient that you analyze or you do your autopsy, your digital autopsy. That's replicating this type of the content in this phone to another place so that you can work on the one you have replicated. So data is not in all cases, and it is just important that you understand in those cases that your data privacy concern is ethically important for you to uphold. In the case of raiding and police just stop you to arrest you, yes, you have the right. You have the right to hold your phone. Don't worry when we get to police station. Don't fight them, but you have the right to tell them you cannot release this mobile device. I cannot release the information you are asking me to do because it's against my fundamental human rights. It's against my privacy and my data privacy ethics. And they will understand that. In fact, police don't want to hear that. They will understand immediately. This one, we just speak Oyinbo like this. I bet just leave and make carry while they go. I bet enter this car, enter this truck. You enter and they will take you to their station. So it is just important. I don't know if I've been able to answer that. And the second one, how can digital forensic be used to resolve intellectual property or cyber theft or resolve cyber theft? Okay. To understand intellectual property, somebody wrote a book and he gave it to you as a manuscript. He gave it to you to review, and you publish it, or you publish part of it. And that's even before the person know anything. You publish part of it. There are strings. That's question document analysis. There are strings. So this is not digital forensics. This is not question document analysis. So when question documents examiner analyze the documents with the reference document is the known documents. That is the manuscript you give to that person. And the question document is the one in question that needs to provide answers to. And when they analyze both, they are going to understand the strings. They are going to consider the strings, the nexus between the two. And if they can link the strings together, then that means the intellectual property has been violated. And this cyber theft. Cyber theft varies. If I want to disrupt your network, I want to stop you from, okay, we are running the same business and you're supposed to apply for a contract. And then I got there, I'm supposed to apply for the same contract, and I got there. And they gave us the same information that we should submit by so time. And I know we are in the same place. So I can just employ somebody to disrupt your network or to use steganography to send one email from an unknown source. You open it, multiple virus start replicating itself to all your systems, and you won't be able to do that. That's I'm thinking about my own business. So you won't be able to send because viruses will have been replicated to all your systems, and I will be the only one to now send. And that is cyber theft. And how can that be resolved? That can only be resolved by using steganography experts. Steganography experts can come up with cryptography tools that will encrypt and decrypt and trace the source of the attack. By the time they were able to trace the source of the attack, they were able to know, okay, this attack is from so IP address. Where is this IP address? The IP address is located at so coordinate. Where is this coordinate? The coordinate is at Asokoro, Abuja. Okay, Asokoro, Abuja. My office is at Asokoro. Can you be more specific? Okay, it's around Aso Drive. in Asokoro. Okay, Asodra, that's my office. Okay, who is there? Then they start asking questions. You now involve forensic psychologists. Then psychologists start asking questions. What is the main thing that you want to do? Okay, this is what I really want to do about this thing. It's really important. Okay, are you sure nobody is trying to sabotage this? No, I'm not sure, but I saw so person. Now you are providing information, and that can actually be investigated. So it's not just no field of forensic is superior to another, and you don't say just because a digital forensic a digital crime has been committed, you must use digital forensic to resolve it. It's a lie. It's a lie. You may use digital forensics to resolve it. You may use the applications of other fields of forensic to resolve that. Thank you. Thank you.
Thank you so much, sir. That was really amazing. Thank you. Thank you so much, sir. So that is all the questions we have, and we are super grateful that you took out of your precious time. You took out of your precious time to attend to all of our questions. Though with everything I've learned today, I can boldly say, even without doing any forensic research, the Nigerian police force is far away from this. That is the honest truth. The Nigerian police force is far away from this. That's the truth. And how to start changing that right now, me, I don't know. Probably there are other people that would who would go in that line and
Actually, we can
direction.
change that. We can change the narrative.
Ah, you
See,
can help us with ways, we'll be glad.
if you know, okay, when I was having my internship, I did some pro bono. I conducted some pro bono training with my team. It's a team of 5 forensic scientists, and we decided to go to different police stations to train, to give them basic forensic training on evidence gathering and evidence preservation. And it goes a long way. And afterwards, we now realize that these people are not properly deployed. Now we are now facing another challenge, deployment challenge. Somebody has been trained on forensic investigation, but the person is now a bodyguard to one politician. How can he use that skill? How can he use this skill? So as you are trying to provide a solution to one, they are creating another challenge. So the most important thing is that this thing should be included in police academy and police college curriculum, so that it's going to form basis for all of them, so they will understand before they leave. So by the time they hear, they understand, oh, yes, this was what they told us now. Oh, no, you are doing contrary to what you were told at the college. And it's really going to... we believe in Nigeria. We believe in new Nigeria. Well, let's keep hope alive, and let's keep doing what we know is right for us. Thank you.
Amen. Amen to a new Nigeria. Thank you so much, sir. That was fantastic and amazing. Interns, I want to see your virtual claps. Your virtual claps, your appreciation, fantastic presentation. We've learned so much. We've been so enlightened. Our minds have been renewed. Words are not enough to say thank you, sir. Words are not enough to say thank you. On behalf of Madam Deborah, who is currently indisposed, we want to say a massive thank you to you, sir. And we are super grateful for taking our time, to dish out from your wealth of wisdom and knowledge. We are so grateful. May the good Lord continue to increase your wisdom and increase your influence all around, and especially in the Nigerian police force. Okay, so I just got a quick feedback from Madam Deborah. she's currently available, because it would be wonderful for her to say thank you in person. And then, Deborah, have you been able to join? We're super glad you could make it. Okay,
Yes,
I guess
thank you
she's
so
still
much.
okay. She's here.
Thank you, Sarah.
Amazing.
Thank
Yes,
you
ma'am.
to the group moderators.
Yes, ma'am.
Thank you so much, Mr. Bolaji. I really appreciate you. I know it's been quite of so um instability with my network where I am at the moment, but it's getting better. So I did key in schedule to share his time with us, and I do not take this for granted. I do not take this for granted, and I want to say a very big thank you to you, sir. I am so grateful for this sacrifice that you have made today. I appreciate your expertise, your time, your sacrifice, and for this wealth of knowledge that you have dished out today. I am so glad, and I say, may the Lord bless you so much for this. No idea about it, the correlation between it and law, I had no idea. And in the space, I knew that it would do my platform a great deal, a great benefit to have you here. And female virtual internship and mentorship program, we say a very big thank you to you, sir. I do appreciate you. So ladies, please share these amazing lessons online and make sure you connect with him and tag him in these great lessons that you have picked today. And this has all
Okay, I guess the network. Wow, amazing. Amazing. Thank you once again, sir. Thank you so much, sir. So we'll have a very quick announcement to the interns. We meet again by 5 p.m. on X Space, formerly known as Twitter, by 5 p.m. for an amazing knowledge sharing session. We want to hear from you. It's going to be interactive. Oh, thank you so much, Mr. Bolaji. We would really appreciate the materials. Thank you so much. For the knowledge sharing session by 5 p.m., the link will be sent to the group. So clear your schedule for that, or plan your schedule to include 5 p.m. this evening, just a couple of hours from now. You don't want to miss it. You will be able to speak as freely as you want to be heard. So please get ready for that. And every other information that you need, the recordings, of course. I know some of you are already asking on the group for this class recording. It will also be sent to you. So further information will be communicated in the group. And any further questions, you can also send them to my DM, and I'll make sure it is directed to the appropriate quarters. Thank you so much once again, Mr. Bology. Thank you to the interns for staying to the very end. I know you gained value today. Please have a blessed day. Thank you, sir. Thank you so much. We can't hear
Thank
you,
you
sir. You're
for having.
muted.
Have a good day.
Yes, sir. Thank you, sir.